everybody's ready to go ahead. Why don't you go ahead?
Ladies and gentlemen, believe it or not, my favorite jury instruction is the burden of proof, because it says exactly what your job is. Your job is not to search for doubt. Your job is to search for the truth. What you just heard was the smoke show continue that Josie started, the defendant started, with her testimony. Look at all these other things, but how much of what the defense argued focused on the 2 days involving Alexavier's death? Heck, how many times did you hear the name Alex or Alexavier during their comments? They brought up the 2011 and 2013 other acts as if that was the entirety of what the state relied on. The state's argument regarding those was less than 5 minutes, and the state's argument regarding those told you exactly what the law says and how to use it. They're the ones that brought up using it improperly. I want to talk first about the accusation about the investigation in this case, and that there was tunnel vision associated with this defendant, because nothing could be further from the truth. The defense gave the example of a puzzle that is missing pieces. There was a puzzle with missing pieces in this case, but it was the defendant that was taking those pieces away from the. When they responded that day, they were first responders trying to save Alex's life. They performed CPR on Alex's body. In the efforts of trying to perform CPR on Alex's body, they moved the pill container. They put it on the bed. They touched it. When this case was first being investigated, as an overdose. That pill container was sent out to the crime lab to see if it had Alexavier's DNA on it. Why? Because law enforcement was looking to see if this was, in fact, an overdose, just like the defendant said. That's why they sent it out looking for Alexavier's DNA. They were investigating it as an overdose. If you looked at the first search warrants in this case, which was brought up, the first search warrants were looking at child neglect resulting in death because they were looking at it as a potential overdose where drug exposure happened in the home. Is that pointing the finger at this defendant? No, that's keeping an open mind. You heard that the defendant willingly gave over her cell phone. You saw the video. Investigator Williams said, we're going to get a search warrant for your phone. She knew they were going to get a warrant for her phone. It was with that information that she turned it over. But the defense paints it like it was a voluntary, here's my phone, here's my passcode, look at whatever you want. That's not what she did. And don't let them portray it that way to you. Law enforcement did investigator search warrants for her accounts, Google, Facebook. But they also did them for Mr. Pedrin. They were also examining him as a potential suspect. You heard that they did search warrants for her and for Mr. Pedrin. But it was this defendant's words to investigators originally, and this is important. That morning, she said that Alexavier was asleep the entire time that Mr. Pedrin was home. Alexavier was asleep the entire time that Mr. Pedrin was home. Why is that important at that stage of the investigation? Because the autopsy is done on February 13th, and that's where they see all the internal injuries. Based on the internal injuries, they now know that this is a child abuse case, that it's a severe child abuse case. But what the defense doesn't want you to know is that the investigators are relying on her word during this portion of the investigation. Her word is that Alexavier was asleep during that time frame when Mr. Pedrin was home. And so what does that mean? That narrows the suspects. Mr. Pedrin couldn't have committed the child abuse according to her words. And so they have now lost probable cause to get a search warrant for his phone. But they don't tell you that. And so they continue to investigate. They have the internal injuries. They have the forensic interviews of the children. And the forensic interviews of the children, in all of the forensic interviews, not one of the children ever says that Mr. Pedrin does any form of child abuse to any of them. A riot, no child abuse by Derek Pedrin. Brantley, no child abuse by Derek Pedrin. Major, no child abuse by Derek Pedrin. But they all point the finger at this defendant alone. Those children were in 2 separate homes, and they talk about hitting, kicking, and choking by this defendant. That's magnificent coaching by some power from above that children in different homes can magically say the same thing unless that's what happened. And so now, they are looking at this defendant for child abuse. Because this defendant's own children say she's a child abuser. And then they get the toxicology results. And they have a conversation with Mr. Pedrin. And I want you to think about what Mr. Pedrin says regarding the toxicology results. I buy Xanax. He's admitting that he illegally purchases Xanax. He's admitting that he illegally purchases Xanax for her. And who has the phone? The only phone with a text message that comes back to Xanax. This defendant. Text message to her mother saying, do you want to try a Xanax? What does that message tell you? She has Xanax, she possesses Xanax, and she's willing to give it out to someone else if they want to try it. Now, she's had the benefit of listening to everyone testify. She's had the benefit of seeing that text message and knowing it's going to come into evidence and having to come up with an excuse for it. And how much did you hear that she was prepared? She initially said that she prepped every week since being charged in this case for the moment that she was on the stand. Think about when she was charged with the offense and she got a copy of the criminal complaint. And it mentions the child abuse, and it mentions the Xanax for the first time. She knows about the results. Who's the first person she calls in this world? Mr. Pedrin. What does she say to him? I love you. Repeatedly. I love you. Do you love me? I want to talk to the children. And what does Mr. Pedrin say? He allows her to talk to the children. You heard arguments from the defense about the theory of the case. The theory of the case. Investigative Sergeant Rich Amundsen testified that Mr. Pedrin is still a suspect. What do you know about this case? You know he was bringing Xanax into the home. Heck yeah, he's still a suspect. You know he committed child neglect. Heck yeah, he's still a suspect. There's nothing that Investigative Sergeant Amundsen said that is not true. But they want you to believe that because he's a suspect in those things, he's a suspect in the abuse and death. That's not what was said. They were asked if he was still a suspect, and the answer is yes. To neglect, to delivering Xanax to her. And you're asked about a working theory of the case. You heard the theory of the case, not from Investigator Williams, who was removed from the case after doing a few months' work on it, is obviously upset about being removed from the case, and hasn't done any work on it since, but you did hear a complete theory of the case from the investigator that's been on it ever since. Let's talk a little bit about the DNA evidence, because the defense wants to make a big deal about that DNA evidence, right? You didn't test the bag that belongs to this defendant. You didn't test the pill container that belongs to this defendant. It was tested. It was tested for Alexavier's DNA. And then when they went back and watched the body cam, they saw CPR being performed. And then they saw those containers being moved. That's Alexavier's DNA being transferred to those containers. The bag is her bag. Of course it's going to have her DNA on it. What they didn't explain and what they can explain, because it demonstrates her guilt beyond a reasonable doubt, is that bag coming down and being put on the floor, is that pill container being emptied out, is that pill container being used to stage an overdose. And what did that buy this defendant? It bought her time. It bought her time that day because the investigators allegedly looked at the scene and said, this does look like an overdose. But then they started putting the pieces together. They started looking at the evidence because what they didn't know when they responded to that scene was all the internal injuries that Alexavier had before he was administered those drugs. When you know those injuries and you know how severely this child was abused, when you know that in the context of this bag and a child having to open that container, and when you know that the pills were dumped in that bag, you know it's staged. The defense also keeps throwing out overdose, 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 as if that's what the medical examiners said in this case. The practice of medicine involves differential diagnosis. It involves looking at the entirety of the facts and the picture. If you look at just the pills and the toxicology results in this case, it's consistent with overdose. That was the question. But you have to look at it in the context of a beaten and battered child who is then drugged, who is then given the amount that could kill an adult human being. Who is given an amount that's going to result in that child being unconscious and dying within hours. That completely removes Mr. Pedrin. There's only one person in the world who had the ability to administer drugs to that child, this defendant. There's only one person who had the ability to abuse that child without anyone else knowing about it. That's this defendant. There were other children in the home. Mr. Pedrin was there. She said Mr. Pedrin couldn't have done it originally. It was only after being charged at trial that she says, this is what I heard in the bathroom. But you also know that didn't happen because you know how severe those injuries are and you know how symptomatic Alexavier would have been. A fractured rib, a lacerated liver, bleeding into his mesentery. You saw the photographs of all of his injuries. You heard that law enforcement had contact with him and saw none of that. You heard that Laura Lee heard a voice of a child that was okay at 10:30 at night. Dr. Quinton testified that both the injuries and the toxicology in his system were substantial factors to his death. So no, it's not correct that if you rule out toxicology as an overdose, and if you look at just the pill matters, that this isn't a homicide. That is not what Dr. Quinton said. And the other forensic pathologist, the one who didn't write a report, if we're going to criticize law enforcement for not writing a report during a meeting with somebody, what about their forensic pathologist who didn't write a report with all of his findings and conclusions? It was left to me asking questions, only to find out that his opinion is that an adult abused a child, that he would have been symptomatic rather quickly as a result of those injuries, and that with that amount of toxicology of Xanax in his system, he would have been unconscious and dying within a few hours. That was their expert's testimony, that he couldn't bother to put in paper despite being paid $12,000. Why? The defense screams. The instructions that you have in front of you say that the state does not have to explain motive. And don't let them put that on the state. That is not the state's responsibility. The state's responsibility is to prove facts and evidence. And the facts and the evidence are that this defendant brutally beat a child and then administered Xanax. There's only one person in the world that could stage that scene, to bring that bag down, to empty the pill container, to put it by the body, to buy more time. Those who have nothing to fear have nothing to hide. Who's the person who's been hiding things and concealing things since the very beginning of this case? Whose testimony wasn't even commented on by the defense? This defendant. If children get something wrong on the stand, they're inconsistent. If children are too consistent, they can't be believed. That's also what was argued in this case. What kind of world do we live in where we can attack a child no matter what they say in a courtroom? It's just never going to be good enough. Because child abuse is a crime that happens behind closed doors, and if it's children that witness it, too bad, so sad. No matter what, they just can't be believed, even when they're that consistent. Those who have nothing to fear have nothing to hide. This defendant has hid a lot. Tell her that you see her. Tell her that you see her for who she is. Tell her that you know what she did to Alexavier. Tell her she's guilty.